Welcome. My name is Anne Toomey and I'm a Professor of Constitutional Law at the University of Sydney. Now, in trying to work out how to make and edit some YouTube videos, I've now seen an awful lot of product reviews for equipment by people who have far more expertise in technical matter than me, and they were really helpful to me. So what I've decided to do is to use my professional expertise to make this video, which is something analogous to a product review, but instead of a technology, for a proposed constitutional amendment for an Aboriginal and Torres Strait Islander voice. So what I'm going to do is I'm going to look at what its purpose is, so we can test whether it's fit for purpose, what's in the box, so looking at the actual words and what they do, how it works, so testing it by running it through some examples, and finally, whether it does what it claims or whether the critics are right. So, as I say in every one of these YouTube videos I've watched, let's get into it. Okay, so purpose. The more I think about it, the more important purpose is, because the purpose gives the context in which to place the words and is what we need to judge the amendment against. Now, this proposed amendment has two positive purposes, the things it's trying to achieve, and two negative purposes, which are the things it's trying to avoid. Now, the positive purposes are constitutional recognition and practical outcomes. The negative purposes are avoiding litigation and protecting the functioning of Parliament. So let's start with the recognition. The Constitution, as first enacted, contained references to Aboriginal people that excluded them from population counts for certain purposes and from the application of the race power. Now, those references were removed in the 1967 referendum, but one consequence of that is that there are actually no references at all in the Constitution to the Indigenous peoples of this land. That makes our Constitution really unusual. Most countries that have Indigenous populations at least reference and acknowledge them in their constitutions. Now, politicians from all sides have agreed that this is inappropriate. It leaves our Constitution incomplete. John Howard, for example, promised a referendum to insert a, quote, positive affirmation in our Constitution of the unique place of Indigenous Australians, unquote. And Tony Abbott also committed himself to correct the great silence in our Constitution. In a 2014 speech, Tony Abbott said, like John Howard before me, and like Kevin Rudd and Julia Gillard, and it seems at least 60% of the population, I am a supporter of constitutional recognition. So it's therefore something that actually has bipartisan support. But the key question is, well, how do we do that recognition? What's the best form of constitutional recognition? What about saying something in the preamble, for example? Well, the first problem is that there is no preamble in the Constitution itself. Where the preamble lives is in the British Act of Parliament that the Constitution sits within. Now, trying to change the preamble of a British Act of Parliament that was enacted in 1900 doesn't actually make a lot of sense, and it certainly doesn't recognise Indigenous people in the Constitution itself. So that great silence, that incompleteness, would remain if that's all we did. Now, we could, of course, introduce a preamble into the Constitution itself instead of starting with the rather unromantic, here, by the way, is my very tatty old Constitution, but let me very briefly show you how a Constitution starts. Starts with a very unromantic table of contents. Okay, so could we fix that? Could we put in a new preamble there? Well, John Howard tried that back in 1999 at the same time as the Republic referendum, but it did not go well. Les Murray, who was one of the drafters of this particular preamble, later said that it had been crippled by compromise and that the people in their mercy took it out and shot it. The problem here is that a new preamble opens up another whole can of worms, or as someone said to me recently, a cannery of worms. And that is about what else you put into this preamble. And also, how might a preamble be used in the future to interpret other parts of the Constitution? In short, this is asking for trouble, and it also completely distracts from the essential issue of recognition of Australia's Indigenous people in the Constitution, so it's frankly best just not to go there. In addition, the dialogues that were held across the country with Indigenous people show that they weren't interested in being recognised in a preamble either. So there's really no point in giving recognition to people in a way that's not wanted. Now, Indigenous Australians instead wanted a form of recognition that went beyond mere words and that could actually lead to some practical outcomes. The insertion of merely symbolic words in a constitution actually doesn't achieve a lot. And we know this from experience. Okay, so here is a question for you. Does your state constitution, assuming you live in a state, does your state constitution recognise Indigenous Australians? Okay, now don't be embarrassed if you're scratching your head about that right now and don't quite know the answer, because just about everyone else is. Okay, people, except perhaps for me and a few others, don't tend to sit around reading state constitutions, and in fact, most people probably don't even know there are state constitutions. Okay, that's a matter for another video. Anyway, the answer to the question, by the way, is yes. Yes, your state does have a constitution, and each one of those constitutions now recognises Indigenous Australians, either in the preamble or in the substantive text. But the thing is, you don't know about that, okay? And why don't you know about that? Well, for two reasons. First, it's only symbolic recognition. It doesn't actually do anything, right? Second, it was achieved by the enactment of ordinary legislation and not by a referendum. So yes, you can change at least parts of a state constitution without a referendum, but again, that's a video for another day. Okay, ultimately the problem with recognising Indigenous Australians in the preamble to a constitution is that it is just words, 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 as Hamlet would say. Those words don't do anything more than simply sit on the page of a document that few people actually read. So can we do this better? Now, this is where the idea of a voice comes in. So let's just think for a moment about what the word recognition means. If you are in a meeting and you are recognised by the chair of the meeting, it means that you are allowed to speak and others let you have your say. So you are recognised by not only being seen, but by letting your voice be heard. Okay? And the same thing applies in Parliament. So you'd think politicians would frankly be aware of this. But anyway, the Speaker recognises a member of the House, indicating that he or she has the right to speak and be heard, hopefully, in silence. Now, in neither case does it give the person recognised some kind of power to dictate what the body then decides. What it's about is about giving the person respect by accepting that they are worthy of being heard. And we give them recognition that what they might say might in fact be useful and influence the meeting or the meeting or the house that's actually making a collective decision. All right, nothing more and nothing less. Now, this is where the idea of an Indigenous voice to Parliament and government comes from. It's a better form of recognition than mere words on a page because it is active, it's not passive. Aboriginal people are actively involved in exercising this voice rather than passively waiting for lawyers and politicians to put some words on a page. It's continuous because the recognition occurs not just once by putting those words on a page of the Constitution, but it works every single time the voice speaks. There is ongoing, continuous recognition. and it's powerful. Okay, so the act of the people in voting in a referendum to approve this voice is itself a very powerful assertion of acceptance, respect, and recognition, which would be a big step forwards towards reconciliation. And finally, and probably most importantly, it has practical consequences. So it's more significant than mere symbolism. Okay, so that gets us to the second main purpose of this amendment, and that is the practical one. Now, the aim here is for Parliament and the government to be better informed when making decisions that have an impact on Indigenous Australians. Now, we all know that with the best will in the world, someone who lives one kind of life does not completely understand the impact of laws and policies on the lives of others who live in completely different circumstances. Sometimes you have to walk in another person's shoes to know that, or at the very least, to listen to them to find out how that law or policy affects them. Now, most people would also agree that Aboriginal policy has not been hugely successful in the past. So hearing the voices of those affected might help to avoid the perverse incentives that are often created, the unintended hardships that could be removed by some small change here or there, the waste of money on this when it's desperately needed on that. So small changes as a result of a better informed decision-making process could indeed have large beneficial consequences. So the practical outcomes of a voice to Parliament and government could be great if the voice produces representations that contain strong evidence based on arguments and concrete examples of policy effects on the ground, and decision makers in Parliament then are prepared to consider whether that information can be used to improve their decisions. To work effectively, there will need to be effort on both sides. So now, what about the negative purposes? What is this amendment intended not to do? Okay, now the first one is litigation. So one important aim was to draft the amendment in such a way as to prevent things being tied up in court in litigation all the time. The proposal for a voice was originally developed as an alternative to a previous proposal to put an anti-racial discrimination provision in the Constitution. Now, that earlier proposal would have meant that Aboriginal people would have had to go to court to seek to strike down legislation that they regarded as discriminatory. And that approach was rejected for a number of reasons, one of which was that it puts agency into the hands of lawyers rather than Aboriginal people themselves, and it turns everything into a legal dispute. Litigation, as we know, is expensive, it's really time-consuming, and it's risky, especially if you have to pay the other side's costs if you lose. So the aim in developing an alternative, being this voice proposal, was to shift away from the idea of challenging laws in courts after they're made to influencing those laws and policies before they are made by providing good arguments about how to make them better. Now, this shifts the action from the legal realm to the political realm, and the amendment is therefore intended to be drafted in such a way as to avoid legal disputes and instead provide political incentives for actions. Okay, now at this point you might be saying, well, how do I know all of that? Well, in the words of the song from the musical Hamilton, I was in the room where it happened. And this was back in about 2014, okay? It was well before the Uluru Statement in May 2017. And in fact, this morning I actually dug out my very first attempt to put that idea into a form of a constitutional amendment, which was dated 22nd of August 2014. So that was the first draft, so to speak, of this idea. So when I tell you what the original intention behind it was, I actually do know because I was there when the idea was first being formulated. Now, the second aim here, the negative aim, is to not undermine our parliamentary system of government. Parliament represents us all through elections and must continue to have full power to make laws. It shouldn't require anyone else's permission to be able to make laws or be prevented from being able to legislate until someone else has been consulted or provided advice. So the aim here is to actually leave Parliament with its full powers to make laws, but to provide a mechanism which politicians and others can draw on to allow the Parliament and the government to be better informed so they make more effective laws and policies, and to leave this to be achieved by political pressures rather than legal requirements and heading off to court. So that's all the stuff about purposes. So now we get to the product view bit where we look at what's in the box. Okay, now we don't actually know the packaging yet, so where they're going to put this in the Constitution. So I do have a little box here. So at the moment, people seem to think it's going to be a Chapter 9 in a new Section 129 of the Constitution. Okay, so that's a possibility. My 2014 version actually had placed it elsewhere. I tried to put in a new chapter, Chapter 1A, because I was a bit wary about sticking it down the back of the Constitution as an afterthought. Thought it was actually a bit more important, so let's put it after the chapter on power. So I had a draft section at 60A, but hey, in the end, it doesn't really matter so long as it gets in there. So let's leave that up to the government to decide where to put it. Okay, so we've got a box. What's in the box? Okay, here we have in the box a relatively short constitutional amendment. Okay. Now, with the whiz of all my YouTube videos, hopefully I'm able to put these amendments up on the side so that you can see them. But basically what we've got is 3 proposed sentences. Each of these sentences would be a subsection of whatever the new section is. So Section 129 or whatever. Okay. So subsection 1 says there shall be a body to be called the Aboriginal and Torres Strait Islander Voice. Subsection 2 says the Aboriginal and Torres Strait Islander Voice may make representations to Parliament and the executive government on matters relating to Aboriginal and Torres Strait Islander peoples. 3, the Parliament shall, subject to this Constitution, have power to make laws with respect to the composition, functions, powers and procedures of the Aboriginal and Torres Strait Islander Voice. Subsection 1 imposes an obligation to ensure that such a body exists. But it doesn't really tell us very much about the body. The term voice suggests that it's a means of being heard, a means of communicating. And the reference to Aboriginal and Torres Strait Islanders suggests that these are the people who are going to speak through this voice. It also tells us that this body shall exist, giving it the security of permanency. It would first, however, need to be set up by legislation enacted under subsection 3, which determines how it's comprised, etc., because it can't exist until something is done to constitute it. Okay, subsection 2 tells us a bit more. It says that the voice may make representations to Parliament and the executive government on matters relating to Aboriginal and Torres Strait Islander peoples. Now, the word may here is important. It's not obligatory. There's no requirement that representations be made on a subject before the Parliament can pass the bill or the government can make a policy. There's no requirement for the voice to make representations on every matter relating to Aboriginal and Torres Strait Islander peoples. It's up to the voice to decide when and whether it makes representations. Now, the second important word there is representations. Other words have been considered and rejected in the past for this type of amendment. So it doesn't say, for example, that the voice must be consulted. Why? Because there's a whole lot of law out there on the meaning of what amounts to true consultation. And if the validity of laws was dependent on consultation, then this could result in huge amounts of litigation and arguments about whether consultation had actually occurred. So the word consultation was ditched. Well, what about the word advice? Now, the initial idea was that this would be an advisory body, but there was also concern about the word advice because it might be interpreted in the future as being binding according to some kind of convention in the same way as ministerial advice to the Governor-General is, by convention, binding. So that word was also later dropped as well. That's why the word representations is a big improvement here. It does not bring the baggage of advice or consultation. Representations are arguments put forward on behalf of a group, so the people represented, to persuade or convince a person or body that is making a decision. So this is actually a good description of the aim of the voice. It is to persuade and convince, but not to demand or dictate. Now, the representations are made to the Parliament and the executive government. Now, some people have recently claimed that this is some kind of a new thing in adding in the executive government here, and it's a big expansion of what was proposed because they say the idea was previously limited to Parliament and bills. But the reference to executive governments was actually included in the very first draft back in 2014. And I'll put a link actually in the description to a slightly revised version of that draft that actually published in 2015 for anyone who's interested in it and the reasoning behind it. So the executive has been included in this proposed amendment since at least the beginning of, at least August 2014. So why? Why include it? Well, because most of the decisions that affect Aboriginal and Torres Strait Islander peoples are actually policy decisions by governments on things like education and health programs, and they're not actually in laws. So if the policy is working badly, but it could work better if decision makers were aware of how it was actually working at a granular level on the ground, then the voice needs to be able to make those representations to the government so that improvements can be made. Now, another important thing about subsection 2 is what is not there. There is nothing in there that requires a government to respond in any way. It's not obliged by the Constitution to consider representations before it acts. There's no obligation to consult first before it makes a policy or enacts a law. And this is because of that negative aim, the aim not to constrain powers of Parliament and undermine representative democracy. So then you might ask, well, what's the point if neither Parliament nor the government is legally required to listen or respond? Now, the answer here rests on politics, not law. If a government has any sense and a well-respected body is making representations to it, which show how certain policies could be made to work more effectively, or why a proposed law might cause unnecessary hardship, or indeed how money could be used more effectively, it's going to pay attention and fix the problems. It's not in anyone's interests to have poor policies and badly operating laws. Now, this of course depends upon the voice being a body that makes well-considered evidence-based representations that show a better way of doing things. If it makes poorly considered representations, which pursue ideology over facts, evidence and practicality, then it may well be that the government does not act on its representations, and it would be perfectly entitled not to do so. Governments do, of course, represent all of us, and they do need to act in the public interest and use public finances efficiently. So the pressure will be on the voice to make useful and valuable representations, because this will be the key to its effectiveness. Well, what about the bit about making representations on matters relating to Aboriginal and Torres Strait Islander peoples? Isn't that too wide? Some people have suggested that maybe it is. Now, again, this same wording was actually used back in my 2014 draft. Now, the reason for drafting it widely was that some laws and policies that apply to people generally can have particular impacts on Aboriginal and Torres Strait Islander people, so the voice should be able to make representations about that too. If the voice makes representations on all sorts of things that have little relevance to Indigenous people, then its level of influence is actually going to be, well, zilch. So in its own interests, it needs to be selective. And we're going to talk about that a bit more when we come to examples. But the other reason for leaving it broad ties back to the negative purpose of avoiding litigation. If you try to narrow it down to particular things, then you end up in court with people fighting about what falls in and what falls out of a particular category. And that's going to waste time and money. Now, some people, for example, say that the voice should be confined to making representations about laws under the race power in the Constitution. Now, first, that would make it a body with actually nothing to do for years on end, because actually hardly any laws have ever relied on the race power. Apart from native title laws and laws about Indigenous cultural heritage, which do rely on the race power, most laws that have an impact on Aboriginal people are actually enacted under other heads of power under the Constitution. But secondly, there would potentially be litigation, or indeed a litigation-fest, about whether laws that can be supported by other powers in the Constitution, such as the Northern Territory Aboriginal Land Rights Act, under the Territory's power, could also be supported under the race power, and therefore the voice powers are activated. Now, while this might make lots of money for lawyers, it's really counterproductive. And that's why the sensible thing is to give the voice a very wide field in which it can make representations if it chooses, and avoiding all that litigation. And if you think about it, what is the harm anyway in the voice making representations on a wide range of things? How does it hurt or disadvantage anyone else? If its representations are useful, they might cause change. If they're not useful, then they won't. Now, this isn't a zero-sum game. No one loses just because the voice can make representations. Other people can make representations to government and parliament too, and they do so all the time. I often make submissions, another form of representation, to parliamentary committees about bills that are before Parliament, usually because they actually ask me to do so and I feel obliged to help. Sometimes it results in change and sometimes it doesn't. Just because I make a submission or a representation doesn't mean I can dictate or control what is in the bill. It's true that I most likely have more influence than many other people. I'm certainly privileged because I have the title Professor before my name, and I also have the skills and knowledge to make good submissions. Most people, however, aren't in that position, and so they join together with others to have their say, or they're represented by a particular body, a peak body, for example, like a charities body or the Australian Council of Social Services, or unions or groups that represent small businesses and farmers, etc. And they do this because they're more likely to have their voices heard and be effective. Now, the Aboriginal and Torres Strait Islander voice would do the same thing for Indigenous Australians, giving them a stronger collective voice. But none of these bodies, including the voice, would have the right to demand or dictate, because we live in a parliamentary democracy where decisions are made by our elected representatives in the public interest. Now, what about subsection 3? It ensures that Parliament has full power to make laws about the composition, functions, powers and procedures of the voice. Now, this is important because it provides the necessary flexibility. While subsection 1 gives permanency to the voice, subsection 3 then ensures that if the voice becomes dysfunctional or ineffective, or ceases properly to represent Indigenous Australians, it can always be reformed, with laws being passed to change how it's chosen and how it functions. Now, some people think the words "subject to this Constitution" in subsection 3 are somehow scary and hiding some sort of a conspiracy. Now, those words are actually standard words in sections in the Constitution that give Parliament legislative power. And they're there to ensure that such powers can't be used to override fundamental constitutional implications, such as those derived from the separation of powers or federalism or representative democracy. And that's why it's necessary to have them in here too. So, for example, Parliament couldn't use its legislative power in subsection 3 of this amendment to give the voice power to make laws or judicial power to determine guilt, because this would breach the separation of powers, which confers legislative power only on Parliament and judicial power only on the courts. So those words, subject to this constitution, actually need to be there to ensure that those powers of Parliament are limited in such a way that they can't override other aspects of the constitution. Now, others think that there's something sinister in Parliament being able to give the voice powers. Again, this is standard terminology. It's used thousands of times in legislation whenever a body is established, because you need to give a body basic powers such as power to employ people, power to own property, etc. Ultimately, it's left to Parliament to decide what powers it should get in accordance with the democratic process. Now, if you're worried that Parliament can't be trusted to make decisions about this, well, frankly, you have much bigger things to worry about, because Parliament has all sorts of other powers to do things, including, by the way, an existing race power, which could already, right now, be used to create such a body and give it powers. So subsection 3 is necessary to make it clear that Parliament retains these powers and they're not impliedly removed by subsections 1 and 2. So what then are the only limits on Parliament's powers to make laws about the voice? It couldn't abolish it altogether because subsection 1 requires it to exist, and it couldn't take away its ability to make representations to Parliament and to the executive government on matters relating to Aboriginal and Torres Strait Islander peoples, as this function is conferred in subsection 2. But otherwise, Parliament has full power with respect to it. That's what was in the box. So let's now look at some examples of how it would work in practice. Example 1. The voice is told by native title holders in the north of Australia that the current native title laws are impeding their ability to engage in economic developments and are limiting their ability to create employment and economically sound businesses. So the voice then makes representations to the government about how existing native title laws might be changed to improve the native title system in a way that advances economic development and employment in areas held under native title. And it provides a strong argument backed up by evidence. The government takes that into consideration and largely agrees. It drafts a bill that implements or would implement much of what the voice proposed, but perhaps not everything. The bill would then be sent to a parliamentary committee for further scrutiny. So the voice could then provide a submission to that parliamentary committee, as indeed could other individuals and other groups, all of whom could have their say. The committee might then recommend further changes, amendments might be made to the bill, it could be then debated and passed, and that would be how a change might be made. Now, in this example, the bill relates solely to matters concerning Aboriginal and Torres Strait Islander peoples, and the voice would probably have significant influence. There may, however, be other stakeholders involved who would also have influence in the process. All right, let's look at example 2. Say, for example, a future government wants to change the law to require all voters to show ID before voting. Photo ID. Now, the voice might well then respond with representations opposing that proposal. It could argue that while such a law would apply generally to all voters, it would have a greater impact on Aboriginal people and Torres Strait Islanders, particularly in remote areas where they are less likely to have photo ID, and that it might have the effect of deterring them from voting if photo ID was required. Now, the government might then respond and say, well, look, this is actually, we have good policy reasons for doing this. We want to ensure trust is maintained in the integrity of elections. And it might say that it's acting on behalf of all the people and it's going to go ahead with that law. But then it might also say, well, but it's not our intention to actually prevent or deter Aboriginal and Torres Strait Islander peoples from voting. So actually we will change the draft of the law to include provisions to ensure that Aboriginal and Torres Strait Islander peoples have ways of voting even if they don't have photo ID. Now, that would be a case where the Voice's submission, in its generality, might have been rejected, but it might still have been successful in achieving specific changes to prevent unintended consequences, which may particularly affect Aboriginal people and Torres Strait Islanders. Any such bill would also likely, again, be sent to a parliamentary committee where other people could also have their say. The mere fact that the Voice made representations wouldn't stop other groups or individuals from also having their say and potentially being influential. Now, the reason I chose that example is that, in fact, such a bill was introduced by a senator a year or two ago, and I did make a submission opposing the bill, as indeed did a number of others, and the bill did not proceed. So that shows you that the system is not such that the Voice would be the only voice involved. Others could still play a role in influencing legislation as well. Now, the third example I've got here is the Voice makes a submission to Parliament opposing the enactment of a particular law concerning counter-terrorism measures. And it has no particular relevance to Aboriginal and Torres Strait Islander peoples, apart from the fact that they're also members of the general population who might be affected by terrorism. In that case, the government and Parliament may pay little attention to the Voice's representations because they are instead focusing on representations made by bodies and individuals with greater expertise in the subject matter. So, what does these examples tell us? Well, they tell us that in practice, the influence of the Voice is going to work on two sliding scales, okay? So first, it will depend on the level of relevance to Aboriginal and Torres Strait Islander peoples. Now, if the proposed law or policy is only relevant to Aboriginal and Torres Strait Islander peoples and no one else, then the Voice would have a much stronger influence, as it would represent those people most affected. If the proposed law or policy has nothing to do with Aboriginal and Torres Strait Islander peoples, other than their status as citizens in the general community, then the representations of the Voice will have probably very little influence. If the law or policy is one that applies generally to everyone, but it has a particular impact on Aboriginal and Torres Strait Islander peoples, then the representations of the Voice may have some influence, here in the middle, on whether any changes should be made to affect how that particular impact is felt. Okay, so that's your sliding scale. Now, the second sliding scale concerns reputation. If the Voice provides well-reasoned advice drawing on strong evidence base and specific examples of impact on the ground, and if it focuses on serious matters of specific importance to Aboriginal and Torres Strait Islander peoples, then it's likely to have a very good reputation and a strong influence. If, on the other hand, it is dysfunctional, riven with disagreement, focuses on the trivial, gives poorly reasoned advice, and addresses itself to matters with little relationship to Aboriginal and Torres Strait Islander peoples, then it will have little, if any, influence. And if it was in that state, then it's likely that legislation would be enacted to reform the way it's chosen and it functions so that it becomes more effective. Now, the problem with many of the arguments by critics is that they all assume that whatever the Voice says will be so influential and effective that it will bind politicians in all circumstances. They see influence as absolute and the degree of influence as static. Whereas in fact, if you look at this reasonably, there is going to be those sliding scales that move up and down according to relevance and reputation. So this now brings us to the issue of how the proposed amendment stands up to criticism. Now, the criticisms largely cluster around the two negative purposes. The drafting of the proposed amendment has been very careful to avoid potential litigation. First, it didn't state that the voice has to be a representative body, because that could have then led to all sorts of arguments about whether the way it's comprised is truly representative or not. So it avoided that trap and simply left how the voice is to be comprised for Parliament to decide. Second, it did not try to narrow down the scope of things that the voice can make representations about, so that there would be no legal arguments about what is in and what is out. So by leaving that category very broad, it leaves it as a matter of politics and the operation of that sliding scale of influence. The voice risks diluting its influence if it makes representations about trivial matters or matters that have only a tenuous connection with Aboriginal and Torres Strait Islander peoples. Third, it does not require any action on the part of the government or the Parliament. There's no obligation to consult or even to consider the representations. Again, this is left to politics and common sense rather than the courts. As an interesting comparison, when I drafted the 2014 version, I was asked to include an obligation, at least on behalf of Parliament, to consider the advice given. So I tried to get around the litigation issue by ensuring that the obligation to consider was a purely internal parliamentary procedure that a court couldn't interfere with. Now, I did this by stating that the obligation was only to consider advice that had already been tabled in Parliament. And that way, there would be no obligation on Parliament to wait for advice to be given. And that such consideration was to be given in debating the proposed laws. Now, this is terminology that the High Court has previously recognised as concerning internal parliamentary matters, and that it would therefore not be something that it would enforce in litigation. Now, I actually thought that was quite a clever way around the problem, and I still quite like it, to be honest. But it's quite interesting that the Albanese government wasn't even prepared to go that far and went instead for an even more minimalistic version in which there's no legal obligation of consideration at all. And that just shows you that this particular amendment has been done with an enormous amount of care to avoid the risk of litigation. What about the other negative purpose, the Parliament one? Okay, so does this proposed amendment make a voice a third chamber, a third House of Parliament? Okay. This argument can be taken in three ways: the literal way, the practical way, and in the metaphorical sense. So in the literal sense, it's clearly not a third House of Parliament. The Parliament itself is defined in the Constitution in Section 1 as consisting of two houses, the Senate and the House of Representatives, along with, not a third house, but the Queen. That is not being changed by this amendment. A House of Parliament can initiate bills, debate them, and crucially, its agreement is required for a bill to pass and to become a law, except in very rare circumstances. Okay, the voice would have no such powers. It's therefore clearly not a third House of Parliament. Okay, what about the practical sense though? Could the failure of the voice to provide representations mean that Parliament was unable to pass legislation, meaning that in practical terms the voice had a veto? No, there is no requirement for a House to receive representations before it passes a bill. So, might the courts imply one and issue injunctions preventing Parliament from passing a bill until it's received representations? Again, no. The courts have always applied this principle of what they call comity, which says that they don't interfere with the internal operations of Parliament. So could Parliament then maybe legislate to restrict its own powers by saying that it will not pass a law until it's received representations from the voice? Again, no, because Parliament's legislative powers are conferred on it by the Constitution, and it can't abdicate or restrict those powers because that would be breaching the Constitution. All right, what about the metaphorical sense? Could the voice effectively have some kind of veto because its reputation is so powerful that all politicians are too scared to vote in a manner that's contrary to what the voice recommends? Well, if politicians took that view, They would be denying their role as representatives of both their electorates and the people as a whole, and they would probably be pretty swiftly voted out because the people do want their members of parliament to represent them. In any case, the influence of the voice is always, as I said, going to vary on those sliding scales, depending on both its reputation and the relevance of the subject matter. Last issue, race. So are we introducing race into the Constitution and dividing the country on racial lines, as some people have said? Well, first of all, we're not introducing race into the Constitution. It's already there. Okay, race has been there since 1901, when a power was inserted to make laws with respect to the people of any race for whom it's deemed necessary to make special laws. We also have Section 25. It's quite an interesting one. It comes indeed from the US Bill of Rights, but it effectively punishes any state that excludes people from voting at the state level on grounds of their race by reducing the representation of that state in the Commonwealth Parliament. So race is already mentioned in the Constitution and has been there for a long time. But the real point to make here is, are we actually doing anything in relation to race here by this amendment? And we need to then go back to the purpose of the provision. Why are we putting it in there? Is it because of race? Would we ever consider inserting in the Constitution an amendment that recognised Scandinavians or Africans or Native Americans or any kind of race? And the answer is no. The reason we're putting this proposed amendment in there has got nothing to do with recognising a race. It's about recognising the Indigenous peoples of this land, the descendants of those who lived here for millennia, the custodians of the cultural history of this nation, and the people who have legal rights and a legal relationship with Australia's lands and waters that actually precede the colonisation of Australia. So that's not about race, that's about being the Indigenous peoples of this land. Second, beyond that act of recognition, it actually gives no greater privilege to Indigenous Australians above anyone else. Everyone in Australia is free to make representations to Parliament and the executive government, just as the voice is. Now, I know you may say, the voice gets constitutional protection for its ability to make those representations, so that gives it greater privilege. But remember, the High Court has also recognised an implied freedom of political communication in the Constitution, and that protects that freedom from laws that might otherwise limit freedom of political communication. So that implied freedom is fundamental to ensuring that all Australians can make representations to government and Parliament. Well, you might argue, by formalising a body to make such representations on behalf of Indigenous Australians, it's likely to increase their influence above that of others. Maybe. As I said, it will depend upon the quality of its work and as to how strong its reputation is, and the relevance of it as well. But remember, there are plenty of other bodies out there that also represent people, from business bodies, mining bodies, trade unions, religious bodies, etc., that also have significant levels of influence, not to mention, heaven forbid, political party donors. Now, hopefully, the voice will use whatever influence it has to achieve more effective laws and policies and better outcomes for Australians. So, overall, what's the verdict? Does the amendment do the job? Is it fit for purpose? Well, yes, I think it actually is. And by the way, I would say so if I thought it was rubbish, okay? It's simple, it's clear, it's elegant. It doesn't put in too much stuff, too much detail. That's the last thing you want in your constitution. It leaves most of the work to the democratic process through Parliament, and that's an appropriate thing. It also has an inbuilt corrective mechanism, so that if things go bad and the voice is not working properly, it can be reformed by the enactment of ordinary legislation. Ultimately, it relies upon constraints imposed by political forces rather than legal ones. What will be important in all of this is the will of the Australian people, as shown in a referendum, which will put pressure on both governments and the voice itself to ensure the system works as it's intended, so that Parliament and the government are better informed when they make decisions affecting Aboriginal people and Torres Strait Islanders, and that outcomes can be improved. And really, ultimately, what is wrong with that? Okay, thank you for listening. I hope that as a constitutional clarion, I have spread some light on the issue for you, and hopefully we'll be able to do so in other videos in the future if I can make the system work. Thank you.